Right now, we want to keep track of what's going on in Kenosha, Wisconsin, obviously awaiting the verdict in the Rittenhouse trial. And we've seen protesters kind of lined up and some of them making speeches. But we don't know whether this trial verdict comes down today. We don't know if it'll be this week. We don't know. We just don't know at this point. But it began early this morning, I believe, 8 o'clock local time.
Yeah, 500 National Guard troops there on standby, I believe, or have been called up to make sure that the peace maintains when the verdict is read.
They'll get a heads up so that they can get in position if there's some concern.
Are we watching graffiti being written outside of the courthouse right there? Okay, well, that shouldn't be happening. But, you know, we'll continue to monitor the situation outside the courthouse.
So for more on what we can expect, let's bring in a couple folks that can talk about it. Constitutional law attorney Kate Cherkasky and criminal defense attorney Will Bruzzo. Katie, let me ask you your thoughts. Is this a self-defense case? Is that all that it comes down to, or is there more?
It absolutely is a self-defense case. It's unique that we have so much video footage here. Each of the instances where Kyle Rittenhouse did shoot and kill or injure somebody has to be analyzed on its own. But if you go through all of those facts, you will come to the conclusion that under Wisconsin law, he clearly had a right to self-defense.
So he's facing 5 felony charges with sentences ranging from life in prison to 12.5 years behind bars. And you can take a look at those right there. The possession of a dangerous weapon was dismissed. Will, what do you think the jury will do? And how long do you think they'll take?
You know, I agree with my colleague. I think that the self-defense is very clear. Here's the other thing. You know, a prosecutor should not bring a case unless they believe the evidence shows beyond a reasonable doubt that the crime was committed. And all the video here, coupled, you know, with eyewitness accounts, I think the self-defense was apparent from the beginning. And, you know, if Mr. Rittenhouse is acquitted, which I think is likely, I think people are going to get very, very angry. And I think that might have been avoided if perhaps the decision had been made not to file. What they should have done is had Mr. Rittenhouse plead guilty to a 17-year-old in possession of a weapon. That he did commit that crime. That was recently dismissed by the court. But I think one of the problems was taking this all the way to trial, given the video evidence, which helps the defendant, in my view. I think it's going to inflame a lot of passions unnecessarily.
If we can look at that list of charges again, and again, number 6 has been taken off, but if we can look at that, the number 5, first degree recklessly endangering safety with use of a dangerous weapon. Katie, I wanted to ask you about this. If you say that everything is self-defense, is there an argument to be made that somebody walking around with a gun, even though we know that that was kind of a no law, no rule kind of environment, is that something that could be considered reckless endangerment?
Well, the self-defense claim in this case will apply to all of the remaining charges here. So to the extent that the jury believes that Kyle Rittenhouse had the right to self-defense, that will obviate that charge as well. The fact that he had the weapon, some people might believe was inappropriate or shouldn't have happened, but we have to go back to what the law requires and what the law allows when you are placed in a dangerous situation, not just with other people with firearms, which we do have other folks that were armed here, but even if they could have inflicted injury or death to you by their own hands or by some other weapon. So the fact that he had the weapon does not necessarily mean that he should be convicted of something if he can prove the self-defense, or really if the prosecution cannot disprove the self-defense claim.
I want to jump down to this because we don't have a whole lot of time left, but this is part of the rebuttal delivered by the Assistant District Attorney James Cross. Let's listen to this, and then I'll get your response, Will.
The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, oh, if you repeatedly smash someone's face, it might lead to injury. And now, a skateboard is a deadly weapon. Everybody takes a beating sometimes, right? Sometimes you get in a a scuffle and maybe you do get hurt a little bit. That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds.
Will, your response?
Yeah, I don't think that's an effective argument. I know what he's saying is that basically Kyle Rittenhouse brought a semi-automatic weapon to a fist fight. He did. But this is part of the risk we take in American society, where you can have a semi-automatic weapon. You allow these people to act like policemen for a day. You know, this was a very dangerous situation that the local police allowed to escalate, and it resulted in this tragedy. I don't think that's a good argument. This idea of like force and like force, that is what the law says, but I doubt seriously that the jury is going to hold him to that. Looking at the video, I looked to me like Rosenbaum was going to inflict some serious damage on him. He was an older man, stronger man, and this is the problem. When you have a gun, all of a sudden, you don't have to use your fist, you just pull the trigger, and that's one of the dangers of having such a prolific number of guns in our society.
All right, we'll see what the jury decides. They are deliberating right now. Will Bruzzo and Katie Cherkasky, thank you both very much for joining us.